Evening, everybody, and welcome to our Division 3 Zoom on collective bargaining. And we're here with Mark Terry, who was graciously accepted an invite to do a presentation on collective bargaining. Mark is a partner at Merrick O'Connell Law Firm, leader of its education practice, and a current Ashland School Committee member. So, and before I turn it over to Mark, I just want to remind people to use the chat for any questions you might have, and we'll address them as we go along. So without further ado, Mark, it's all yours.
Thank you, Barbara, and thanks for having me. I enjoy doing this, and I've been practicing this area for 29 years, I guess, at this point.
Wow.
And it's still amazing to me what types of things come up that I've never seen before. So I can only imagine what it's like for an average school committee member. And before I put the slide deck up, I'll just say that I will try to watch for Q&A or questions in the chat and hit them as we go. If I'm not doing a great job with that, I will come back to that and look for questions afterwards. I don't think my slide deck, the prepared material, will go more than about half of the hour that we've set aside. And my hope is to be able to answer as many questions as possible. And so I certainly encourage you to raise your hand or put something in the chat. So I guess I'll go ahead and share my screen here. And let's see. Where's the technical part of this? Not the right one. Okay. All right, you should be all seeing this really horrible picture of me right now. Are you seeing that? All right, good enough. We're going to move past that so I don't have to look at myself for very long. Excuse me. So as I started saying, we were just chatting before getting going on this. I think one of the things about collective bargaining that is a challenge for school committee members is, you get elected or appointed to your school committee, and you find out one of the things you're responsible for is collective bargaining. It's a law. There's a framework around it we're going to spend some time talking about. And you rotate in and out. You may do two-year term, 3-year term, 4-year term, whatever you have for your school committee. And you're dealing with people that are in the union, have union representation, and there's a lot of stability there, right? Those folks tend to stick around for many, many negotiation cycles. And so they have the benefit of history and they have a benefit of a little experience. And my hope is to try to give you a little bit of information to help balance that out a little bit and give you an opportunity to sort of ask some questions and pursue things that are of particular interest to you. And Barbara, I am showing on screen. You're seeing the slide deck now? Okay, great. All right, so what we're going to try to do here for tonight is cover the things you're seeing in the overview, talk a bit about the legal framework of collective bargaining, some differing bargaining approaches, preparation for bargaining, what you should be doing before you get to the table, what ground rules look like, and we'll talk about what those are for people who aren't familiar, some basic strategies, some more advanced strategies, and then some tips perhaps of sort of how do we do this, how do we do it well. So moving on to the first point is, as I said, collective bargaining is covered by a law. For people who aren't familiar with state law, you might think of the National Labor Relations Act, which is just the private sector federal law. The state law mirrors it in most respects. And what it really says is that employees can join together to form, join, or assist any employee organization, which is another term for union, for the purpose of bargaining collectively on questions of wages, hours, and other terms and conditions of employment. And there's protection for people who do that. That's the basic framework of the law. That's where the rights come from. With respect to the school committee, you are what's called the exclusive bargaining representative. And that is defined in the law. It gives the school committee, rather than the superintendent or anybody else, the authority and responsibility to negotiate collective bargaining agreements. And that's, I think, an important topic or an important point, because That means that how you do things, who's involved, what that looks like, at least as it relates to the school district, is the decision of the school committee. Now, there are some school committees that will have heavy representation, some that will have their superintendent do collective bargaining, and a variety of different things that we can talk about different ways to construct a team in a minute. But this is the school committee's authority by statute. And so it's really important that folks understand that because that means you have a voice and an important voice in the process. When we talk about what bargaining looks like, there's sort of this 5-step structure in place. This is supported in the law. This is what the law calls for. And the first step is bargaining, traditionally face-to-face bargaining in some kind. During COVID, we did it by Zoom. But there is this exchange of dialogue that happens between the parties, representatives of the school committee, representatives of each bargaining unit. And I use the term bargaining unit. Some people use the term union. Those are different things. The MTA, as an example, is a union. I'm in the Ashland School Committee. We have the AEA. That is a union. The bargaining unit is a specific group of people we're talking about: your teachers, your paraprofessionals, your clerical employees, your custodians, et cetera. So I may use those terms without thinking about it, but that's what I mean when I say that. So there's bargaining. There's a discussion of ideas that's going to happen. If bargaining fails, if it's not successful, the next step in the process legally is to go to mediation. That is where the parties basically are saying, look, we've tried and we're stuck. And so you can petition the state for a mediator from the Department of Labor Relations, and their job is to try to help the parties get to agreement. Nothing a mediator can do can force anybody to do anything. And so while some people think of mediation as a failure point, to me, I just think of it as like, it's not a big deal. It's just another step in the process. Taking somebody to mediation is not a big thing, although sometimes unions will feel like they are taking some action, or their members see them doing something. And so from that perspective, sometimes they view it as sort of an escalation of the process. But to me, there are times, lots of times, where, like, I think we're not really being constructive anymore, and I'd rather go to mediation. Mediation, as I said, is not binding, so it's possible that you're not successful in mediation. The next step thereafter, and I've had very, very few of these. I actually just had one filed within the last month or maybe two, and it's really the second, third time I've had it in 29 years of doing this. Fact finding is a process where, if the parties are really stuck, you're certified to fact find. The Department of Labor Relations will send you there, and the fact finder is a neutral person, typically also somebody who acts as an arbitrator for grievance arbitrations. And they will listen to the parties' respective positions and say, listen, I've listened to both sides. I understand why they think their positions are fair. This is what I think is what you should do. But it's non-binding. And that's really important to understand too. It's non-binding, which is part of the reason why so few people end up in fact finding, because everybody kind of thinks of it as a colossal waste of time and money. So it's really rare to end up in fact finding. If you end up there, as it appears I'm going to be with the client, you go through this process, you receive a report, you come out of that process, and then you're supposed to take that report and bargain some more. The idea is that, geez, the parties were so entrenched in their positions, but now a neutral's given us a new sort of light on things, and maybe that'll help us come to some sort of resolution. The fact finder's report by law is confidential for 10 days. That's when you're supposed to bargain. After that, the report becomes public. You can still bargain. If you go all the way through that and you can't come to agreement, you are at legal impasse. And in theory, the employer can, at that time, say, we're implementing our last best offer. So when clients say to me, I want something in bargaining, I usually tell them, like, you can get almost anything you want, but there's a lot of process to get there. And usually, well, before we get to impasse, which again, very, very rare, the parties do come to some sort of agreement. So that's your basic framework. What you don't see in there, and I'll speak to this in a few minutes, you don't see strike on there. You don't see strike, yet we all know they're happening, right? So I will touch on that in a little bit. So just rounding out the legal framework here in the next couple of slides. what does it mean to bargain in good faith? Both parties, instead of both parties, both the school district's team and the union's team have an obligation to bargain in good faith. And what that means is sort of the absence of bad faith. That's often the way the Department of Labor Relations talks about it. So things that can cause a party to fail to meet their obligation is refusing to negotiate. We're not going to meet with you, or we're going to meet with you, but we're never going to submit proposals, or we're never going to respond to your proposals. Surface bargaining, which is really not engaging all that much and just sort of pushing things off to the side. No, we're at the table, we're sitting down here, we're talking with you, but I'm not really exchanging in anything, sort of a different version of the refusal to negotiate. Regressive bargaining is an important concept to keep in mind. So what regressive bargaining means, excuse me, is that the parties are always supposed to be moving towards a middle ground. They're always supposed to be getting a little bit closer to agreement. And it doesn't have to be any major increment, but if you're thinking about just compensation and the union wants 10% and the school committee is offering 2%, if the union moves to 9.5% and then the school committee moves to 2.5%, the next move from either party shouldn't be backwards. The union shouldn't go back to 10, the school committee shouldn't go back to 2. That's moving backwards, right? And so regressive bargaining is a failure to bargain in good faith. It's important to keep in mind that you don't necessarily look at things as an issue by issue when you're talking about regressive bargaining. You look at the totality of what's on the table. So sometimes what looks regressive and moving back from 2.5% to 2% really is not if there's some other give that's worth more. Some piece of language that the parties are really fighting over, or something else that's worth more than the 0.5%. But the goal is, again, moving forward, not moving away, which prohibits things like take it now or it's not going to be on the table next week, as an example. Failure to provide information. Information, we'll talk about preparation and information gathering in a little bit, but there is an obligation on the part of both parties to provide information so that they can fulfill their obligations to bargain. And so it's not uncommon to get fairly lengthy information requests at the beginning of bargaining from the union around what the composition of the bargaining unit is, how much people are making, what step they're on when they're hired, and things like that. Unilateral changes are a circumstance, and this really is only something that an employer can do, is when we make a change without bargaining when we had an obligation to bargain. That usually is not much of a part of the collective bargaining, the negotiation process. It is more likely something that happens during the term of an agreement, but it is important for the concept that when you're negotiating, you have to bargain over all the changes you want to make. You can't just get to an agreement on one thing or just say, well, I'm just going to change this one thing anyway. You still have to kind of do that through the bargaining process in most circumstances. And then last, lack of sufficient authority to bargain effectively. This doesn't come up very often, but what it contemplates is just sending somebody in to do the bargaining. Say, oh, yeah, we sent in an assistant principal from our high school to do all the bargaining. And all they do is they show up, and then the union says, well, we want all these things. And they'll say, well, I can't really bargain with you over that. I'm going to have to go back and talk to somebody else. Without authority in the room to really make compromise to a degree so that negotiations can move forward, that's a lack of sufficient authority. Don't confuse that with the idea that a school committee might say, we're giving you authorization to do certain things, and that authority might have a limitation on, right? The school committee says you can go up to 3%. Well, at some point in time, you may hit 3% and the union is still asking for more. The fact that the school committee put a cap on the original authority doesn't mean that there's a lack of sufficient authority on the part of the bargaining team. It's just that you have to have some ability to move forward and have an ability to represent the group. And that is applicable to both parties. When we bargain, there are three types of topics that are subject to discussion, what are called mandatory subjects, permissive subjects, and illegal subjects. Most of the things you're ever going to hear about are mandatory subjects. These are wages, these are leave time, these are how you decide how layoffs are implemented or transfers are granted. That's most topics that you're really going to ever think about. Permissive subjects are things where the parties can bargain, but it's also okay for one side or the other to say, no, we really don't want to talk about that. And I always struggle to think of a great example of a permissive subject. And then illegal subjects are really things that where in most cases, the employer has an authority to do something, and no matter what they do, they can't give it away, right? So that, as an example, the superintendent has the authority to approve leaves and has the authority to approve hiring and firing. You put something in a contract that said the union president will be the final determiner of who gets hired. That's an illegal subject because it is conflicted by specific state law. And so those things don't come up very often. Sometimes there's a random issue about benefits or retirement when the union says, well, we want something to count towards our retirement. School districts typically don't control that, right? You're not a retirement board, you're not PARAC. And those usually are resolved by a little piece of information and understanding, you move on. So the last slide on the legal framework here is sort of the leverage, right? What do the unions have? Well, sometimes they have the political tactics, and this is absolutely what we've seen more of over the last 4 or 5 years, particularly under the MTA's leadership and Max Page. They've been very aggressive, constant attacking of school committee members, attacking of superintendents, votes of no confidence, all sorts of misinformation campaigns, and that's my word. I suppose other people probably have a difference of opinion on whether things are true or false, but all sorts of community type of activities that are intended to give the union leverage. Those are real things, and we have to talk about them, and they've impacted how we do collective bargaining. I'll come back to a point in a little bit when we talk about ground rules around political tactics, public communications, and things like that. But certainly, unions often have the ability to put pressure on us because they can get people wound up, they get parents wound up, and quite frankly, they're not confined by full truthfulness. There are lots of times where I've seen unions put out something on Facebook or whatever social media post, and it's patently false. It is not what was proposed at the table. And I always question whether to give them the benefit of the doubt and say that they just didn't understand it, or whether or not they're just trying to get people wound up. And I think there's probably some of both there. So it's political tactics, picketing, communication to parents, citizens, strikes, right? So I write no strike here because they are illegal. And hopefully people know that. The reality is that thus far, the remedies for strikes in terms of penalties and things like that have not been substantial enough to stop people from doing it anyway. And while individuals can be found to have engaged in unlawful strikes and lose their jobs, the Department of Labor Relations has not been particularly helpful to us in finding that, for example, a specific union president condoned or called for a strike. And the MTA is very good at counseling people as to how not to get caught. Right? If you ever find out how it came to be, it's sort of like just the room decided to strike, as opposed to somebody called for it. And so it's always very, very difficult to tie that down. We're in this period where strikes are a real thing to be worried about. I will say to you that I think the MTA strategy largely is to create chaos and disruption, and it doesn't really. The strikes aren't really about getting something better for Marblehead or any of the other communities that we're recently on strike, as much as it is a broader band approach to cause people to worry about strikes and to some degree be more agreeable to things to avoid the strike or the risk of it. And I'm certainly going to be happy to talk to you more about strikes as we get there. I will say I've been fortunate. I've been able to avoid having any of my clients go, even though there were a couple where I thought for sure that's what we were going to have. And then the last thing, there is a mechanism about binding arbitration in the law. It is not mandatory, and I would not recommend using it because the reality is then you're giving up control over who writes your contract to an arbitrator. This is basically the binding version of fact finding, which I spoke about before. So let me sort of turn to the two different models of bargaining that are most common. Some people refer to there being a hybrid, but there's traditional bargaining, which is characterized as position-based. You propose this, I propose that. Often it's more contentious. It often puts the desired outcome before the problem. People don't come in and say, well, I'm really concerned about how we do this. They come in and say, I want that. And for that reason, it can have a very detrimental impact on long-term relationships. It can make it so that you're always focused on trade-offs and packages, which is an effective way to work things out if you have to. But it can be quicker to resolution if it's not contentious than interest-based bargaining. One of the things that I think, Barbara, you said before we got started is, you were able to have your negotiations put off for a year and you have a good working relationship between the superintendent and the union. I will say to you that I think that relationship is perhaps the single most important positive relationship to maintain in any school district in terms of labor relations. If that relationship is strong, it can make negotiations so much easier because they've been working to maintain some positive dialogue about issues that come up along the way rather than having them pile up. In my school district, we've been fortunate. My superintendent's had an excellent relationship with our union for many years. Our negotiations typically take 3 sessions and we're done. And I owe a lot of that to the long-term relationship that others have invested in. Comparing traditional bargaining to interest-based bargaining is a whole different animal. It is designed so that people come to the table and say, look, here's what I'm concerned about, rather than what I want. And there's a process that you use through interest-based bargaining, which includes a joint training for everybody who's going to be involved in it to identify issues and problem solve. So this is what the system kind of looks like. I'm not going to spend time talking about it because if you're going to do it, you're going to have a trainer that's going to work with your bargaining team and the union's bargaining team to educate them on that. It can be a healthy process. It also can be something that takes longer because there's a lot more processing. I'm involved in this with one client right now. We have 120 issues on the table for discussion. It's going to take longer. Last time we did it was about 6 years ago. We had 55 issues on the table, and that still took some time. So there's some pluses and minuses here, but I think for folks who have good working relationships, interest-based bargaining can be a real win-win. So we talked before about preparation for bargaining. And so there are a number of things that I certainly recommend people do as sort of a matter of course. They're largely listed out here. Review your CBA. So if you're talking about the teacher's CBA, what kind of issues have we had come up since then? Click on somebody wanting to come in. What issues have we had come up since last time? Have we had grievances? Have we had misunderstandings or issues that came up and they need to be resolved? Don't lose track of those. Those should be considered as part of your bargaining strategy. Get input from the administrators in terms of what's presenting challenges to them in the contract in terms of what they want to do in their buildings. Evaluate your financial means, evaluate finances and concerns compared to the market as appropriate. And on those two, the financial issues, one of the things, and this, I'm going to give a free plug to this group called ArcsEd. A lot of school districts have started using them. I have no financial interest in them whatsoever. But I will share with you that they have data. They take collective bargaining agreements and sort of break them down so that you can have more access to better information. And they update that every time a contract is negotiated. So think about that. I don't know the price tag on that, but I know a lot of my clients have been using it. And it's been very helpful to keep track of what's going on, what the deals are, and to kind of have that at your fingertips. And from what I understand, they provide a lot of support along the way in terms of assessing cost and things like that. Certainly, next bullet point, you're going to draft proposals if you're using a traditional approach. If you're using the IBB model, you would draft issues. What are the issues we're concerned about? Prep time, fair compensation, leave time, et cetera. Decide who will represent the district. And I want to pause on this one because there are different models. There are places where I almost negotiate exclusively for a client. There are other places where the superintendent does it on their own with support from counsel from afar. And there are places where you have 2 or 3 or sometimes more, but hopefully not too many more, school committee members who are part of the bargaining team. And all those models have pluses and minuses. They tend to sort of work as a matter of history more than anything else. I do find that a lot of districts where they have positive labor relations, the superintendent can get a lot of the contracts done pretty quickly. And the practice seems to be school committee members are involved with the teachers. And then once that's done, you may see the superintendent just take care of the other units, fairly quickly. So they're different. There are different pluses and minuses. I will say one of the questions I was asked to speak to, or one of the issues I was asked to speak to in preparation for this was, should you have counsel at the table? And I will say to you, certainly as an attorney, of course you should, right? Keep your counsel busy. Um, Truth of the matter is, I think it really depends case by case. If you are having contentious relations in this environment where the possibility of strikes is real, I think you really have to think about having counsel at the table. If you have positive labor relationships and you've worked without counsel at the table in the past, there's no reason to change that. You may hit a circumstance, one of my clients did about 16 months ago, where they had positive labor relationships. They had done interest-based bargaining, sort of, and they walked into negotiations in, I think it was December of 23, and walked in and saw 80 people in the room. And we'll talk about silent representatives in a minute. But they walked in and said, "What is all this?" And they found 4 different bargaining units instead of one. And they were like, "We need to get counsel," and so they brought me in and we negotiated those 4 contracts over the next 11 months. So there's certainly is something you should consider, but I think every district is different, every contract is different, and have a conversation with your counsel about where they can help and where it might be overkill, to be honest with you. But at a minimum, just get an analysis of your CBA, and for any legal guidance issues, there's a lot changing right now. Out of Washington in particular, we're still figuring out what it really means, but there certainly are things that change in education all the time. And at a minimum, you want people to look at your contract, you want counsel to look at your contract and give you a sense of where you are. So after you've done the preparation, that's about when you should be actually sitting down and doing ground rules. What I'm going to give you here is sort of traditional ground rules, some of which don't really require a lot of discussion. Others I will touch on in more detail. Size and membership of the team. How many people are you going to have? Who are they going to be? Superintendent, school committee members, business manager, things like that. Who may be present other than the bargaining team? You always want to have the ability to bring an expert in. That expert can be a health insurance consultant. If you're talking about health insurance, that person could be a particular employee who has specialized knowledge within the district about a particular issue. When those experts come in, they typically are coming in to share information and perspective, but not be a part of the bargaining process and leave. So they're not a part of the bargaining team. It is important on bargaining teams that you understand the silent representative issue that's going on out there. In the last 4 to 5 years, the MTA has, I would say, taken advantage of and tried to stretch to an unreasonable degree, in my opinion, the number of silent representatives it is bringing to the table. There is litigation pending, also out of the Marblehead strike. I believe it's still going forward, where the school district filed an unfair labor practice charge asserting that the number of people in the room as silent representatives was so substantial that it was effectively not bargaining in good faith. A silent representative, I should have said this first, is basically considered by law to be a member of the bargaining team, but not a speaking person. A person who sits in the room, observes, is available to participate in caucuses with the union. This is a place where, in my opinion, the MTA strategy is to put a lot of people in the room in an effort to try to create a more intimidating environment. I think it actually has some pluses to some degree on the management side because, quite frankly, in my opinion, again, a little biased, management folks tend to be more realistic about the outcomes than the union folks do. And sometimes there's a better opportunity to take your message to the larger group when they have, and the largest group I think I've seen is about 100 silent representatives in the room. They have to hear directly from you. The message you put out doesn't get filtered through other people. Doesn't get filtered through the union bargaining team that might have their own agenda of what they want to share and how they want to share it. But silent representatives, I'm be happy to take some questions on this, are definitely a thing. They are varying degrees of participation. I've had one place where it's like 2 people, and like I said, on the other end of the spectrum, somewhere near 100. So that certainly is something that's been going differently in the last few years. Can negotiate over where and when meetings will be held. One way to control silent representatives is to pick a small room, but understand location is a negotiable item. You can hold caucuses, which is just a meeting among your own team to strategize. You can define the length of the session, cancel sessions, decide whether there's going to be a limit on proposals, either by number, which is pretty rare, or by timing, which we typically would say, all proposals will be on the table no later than the second or third session. And you don't want that to be indefinite in most cases, at least that's not my practice. The other place where we've seen a lot of changes in public comment. This is not your school committee public comment, but in terms of what people are saying while negotiations are ongoing. And this is, like I said, definitely a change in the last few years. Your negotiation strategy has to include some sort of communication strategy as well. Typically, school committees don't want to be the first one out of the gate to put something out and to sort of start saying things about how bargaining is going. But it is something you have to be mindful of. In the old school, and sometimes they still agree this, there's an agreement, no public comment. You keep everything quiet. That's rare now. The MTA is encouraging people not to agree to that. So public comments, you may want to try to control that, but if you can't, you need to think about your communication strategy well in advance and what your messaging is going to be, and that also influences how you position things and present your proposals. Last two things are just boilerplate. All tentative agreements are subject to the final package, which means you reach agreement on parental leave. Nothing goes into effect until you've resolved all issues and both parties have ratified it, meaning the bargaining unit and the school committee.
Excuse me, Mark, there are a couple of questions in the chat on silent representatives.
Okay. So
that might be a good time to answer them since we're on the subject.
That's probably a good idea since I didn't have the chat box open. All right, let's see what we got here. In a recent negotiation, a member of the MTA was at our meeting, and although sitting with the silent representative, also tried to talk to us. So that one of the things that can happen, and you certainly have the right to say, look, you're a silent representative, you can't speak. I've had a couple circumstances where the parties have agreed that somebody had a particular perspective, but if the silent person is a silent representative, they're a silent representative. Keep in mind that generally speaking, bargaining teams have the right to change their membership. So, you don't necessarily want to pick a battle on that. When at the end of the day, they can say, all right, we're just going to make that person a part of our, what they call core team. But good point. Yeah. And we've certainly seen other circumstances of MTA reps coming in and throwing some sort of verbal grenade and then walking out. And that could be a challenge too. Let's see. So one question about ground rules. Generally, are they a permissive subject to bargaining? Yes, they are, which means that no party can insist that you have ground rules at all. The reason being that you have an obligation to bargain over the contract, and you can't hold up the fulfillment of that obligation based on getting ground rules or not. So it is possible, although rare, that you might have a group say, we don't want ground rules at all. And the truth of the matter is it doesn't change a whole lot, but certainly when you talk about things like public comments and all that, you should anticipate that might be where they're going. Next question, should silent representatives get handouts or just the official bargaining team? So the MTA is getting a little bit more technologically savvy. I typically bring handouts just for the core team, and for bigger districts, what I've seen is they bring a little scanner and they scan it and put it in a drive, and then everybody has access to it with their laptops or their iPads or what have you. I certainly wouldn't say you can prohibit that, but in terms of how many copies I'm really bringing or who I'm sending things to, I send it to the point person or have enough for the core team, and then let them worry about what they want to do with it after that. Let's see. A couple other, question, do I know if the AFT uses similar bargaining strategies as the MTA? I'll be honest with you, I don't have any districts that are AFT that I can think of. My understanding from some other colleagues at other firms that I talked to is that the AFT has not used the same strategies, at least not to the same degree. Okay. So why don't I close the chat now for a minute or two, and we'll we can come back to that, and certainly when I'm done with the slide deck, I'm going to shut the slide deck off, and then I can see hands pop up in chats and all that a little bit better. All right, that was ground rules. Thank you for the question on it being permissive subject. That was a good question there. So these are places where, oops, there we go, where the ground rules are a little bit different for interest-based bargaining. Again, I'm not going to spend time going through these things because if you're contemplating interest-based bargaining, you're going to have a training that kind of integrates the development of ground rules into that. So I won't spend time there. And if people have questions about IVB, I can certainly come back to it. So basic bargaining strategies, you're at the table, and sort of the traditional things we expect to see unions asking for really big basic wage increases these days. And, they're not realistic. They never intended to be. But they ask for, both parties will be aggressive. They ask for 20%, you offer 1 or 2%. And maybe you're going to end up at like 3 or 3.5 or something like that. And I expect those numbers are going to start going down in the next few years here. So, basic strategies are ask for the sun, the moon, and the stars. Be really slow in your counter proposals, not in timeliness, but in terms of how much movement you're willing to make. I'd say is match the nonsense in economics, right? They ask again for 20%. You say, well, if you're going to ask for 20, like how am I going to give you, what I really think I can right away? Using hold tactics or to move things slowly. By just saying, no, we're going to reject that. No, we'll hold on that, get back to you. It's helpful for you to evaluate a proposal, and it's fair to take the time to do that. But sometimes in basic bargaining, we, just kind of move slowly because you take a little time and sooner or later the union starts showing what they really want. And that's really the next point, which is to try to identify what they really want. And even if you think you can agree to them, you might hold off until that becomes a tension point where if you finally agree to it, they're going to feel good. They won that point because it built up in importance by saying no for a while to the point where you're like, okay, we can agree to that and we'll get a deal done. And a reminder here, avoid the regressive responses as we talked about before. What I like to encourage clients to do is take a little bit more of a longer term approach to things. Look at contracts. First thing I do when I'm doing negotiations with a new client is I look at the contract and I try to evaluate it sort of top to bottom, figure out what needs to change here. Where is there opportunity for improvement? And that'll change over time as what the district's trying to do changes over time. So your needs will change, but you want to kind of start with the idea of a long-term plan. And the reason you want to do that is because it gives you an opportunity to obtain proposals when you're making gives and takes, right? They want a lot of money. They're likely, if you're going to give them something more than you might otherwise want to, you might be able to get something that's really helpful to you in the long term, right? So if you have a long-term plan, we're looking to kind of enhance management protections over control of the district and manage things in the long term and look at things on a financially sustainable basis. And then kind of execute short term by looking at sort of what's going on in the marketplace and what are their opportunities to kind of cash in. And that gives you a better opportunity in the long term. I'll give you one little example. For 20 years, we've been trying to get rid of sick leave buybacks in contracts. We first started doing that, but geez, when's this ever going to make a difference? I now have been doing this long enough where some of the people are saying, oh, we can get that language out of there because nobody's eligible for that sick leave buyback on retirement anymore. They've all retired. They're all gone. So keep an eye on sort of long-term opportunities there. The other thing to think about in this longer-term approach is trying to look at your contracts sort of as a collective, right? If you have 5, 6, 7, 8 contracts, there may be language that's important to you that one unit isn't going to care about. And I'll give you an example. A lot of contracts don't have great management rights provisions in them. These are things that preserve your ability to make decisions. And so one of the things I like to try to do is if I find a unit, I have one client in particular I'm thinking of, had a couple custodian units, and I knew the bargaining agent for the union there didn't care about management rights. She said, fine, whatever. So we got it put into the 2 custodial contracts. And then with successive time, we were able to negotiate the same thing into the tutor's contract, the paraprofessional's contract. And now we're at a point where the only contract that doesn't have that same language in it is the teacher's contract. So we built a favorable pattern around that issue where we can go to the most difficult unit in most school districts, and say, look, everybody else has it. Why do you think this is, why don't you want to agree to the same thing everybody else has? And so look at those types of issues and see where the opportunities are to start to build patterns of things that are more favorable to the district. And so that's kind of the second bullet point as well, except with wages, right? Find units that are more agreeable and try to build a pattern. So you're like, hey, we gave the paraprofessionals 3%. Why do you think you should get 5%? And understand the economics and comparability. And that goes back to sort of the recommendation I had about perhaps using ArcSed or getting that information on your own. All right, so how do we do this and how do we do it well? It's really important, and any negotiation book you pick up, it's really about trying to understand where the other side's coming from, right? And so it's important, in my view, to talk to people, understand what they're looking for, why they're looking for it. Everybody wants more on the union side. There's an old union saying, I forget who came up with it. What do they want? Three things: more, and more. There's some truth to that, but if you can start to really drill down, it gives you a better ability to understand what the real core problem is they're trying to solve. And often it's not what the proposal is, or you find out there's really nothing there. So, if you want to do this well, I think it's really about active listening, asking lots of questions, and trying to understand what the core problem is that you're trying to solve, even if you're in traditional bargaining. IBB is built more for that. But traditional bargaining, it's not that much different in the sense that you're approaching that dialogue in a different way. Be sure to use clear, concise, precise with your language. Lawyers get hung up on small details. I think it's Bruce Hornsby in The Range, if I remember right, said that, and it's true. We do. You want to be careful about your wording. The words that you put on a page make sense to you and the other people in the room. 5 years later, different people are looking at that contract and going, what does that mean? So really try to take the time to be precise about it. Using language about practices or, from this time forward without specificity just creates problems for you down the road. Maintain bargaining history, which is really taking good notes about what's going on. You want to have a history because that becomes important to interpretation in the future. And as I said a minute ago, want to avoid terms like practice or the current, or we're going to keep doing it the same way. That changes over time without you realizing, and it becomes a problem to interpret. Other tips: use package proposals. Package proposals means not just I'm going to give you a response on wages, but all right, we can package a response. We'll give you this wage, this parental leave, and you give us this concession on sick leave and management rights, as an example. You put all those things together. Doesn't always get accepted as is, typically doesn't, but it starts to bring the idea of closure into the room. It starts to give people an ability to start to think about, what kind of things can you package or naturally go together. Off the record proposals are effectively when you say this doesn't count for aggressive bargaining, but you're really telling the other side what you're willing to do, so that if they reject it, you can sort of say, well, okay, we told you off the record we could go to 3%. But you're rejecting that, so our last proposal is still valid, so it was 2.5. Back channel communications do happen. It's not always a bad thing. For the union president has a good relationship with the superintendent to knock on the door or the other way around and say, how can we get past this? My only advice to you is make sure that's done deliberately and with the idea that the whole team understands that and thinks that's a good idea. It is not technically correct, but it often leads to deals. And so my superintendents are very, very good with this. And I've said this before when we talk about mediation, but never be afraid to walk away from the table. There is nothing that is going to compel you to get a deal done today. Threats of strike or not, if they're threatening to strike, at this point, I just believe that they're going to do it or they're not. And so if something doesn't make sense, or you feel like you have to evaluate it, don't get pressured, right? This is kind of when you're buying a car, same thing, right? You get your best deal when you walk out the door. So don't be afraid to walk away. And then the last slide here is, how do we do it well? Well, take advantage of the drafting of documents to take control of the language. there usually is either a CBA, like a red line track changes, CBA that you're working on, or MOA, memorandum of agreement, that's being drafted to reflect the parties' changes. You want control of that on the school committee side. Typically, you're better with the language. You really know what you are trying to say if you have counsel involved. We typically are better at drafting in more precise ways than a lot of the MTA reps. And if you can control the document, you're putting something before them to react to rather than have to clean up the mess that they might make or what have you. And then the last point, just make sure you're communicating with everybody involved and sometimes with the public. So let me end the slide deck there, just officially put the questions up there so I can stop sharing.